TMZ recently made waves on social media when they published an article about the CryptoZoo class action case, calling this basically an official declaration that Logan Paul won and that the judge decided that no reasonable juror would find what he said misleading or fraudulent. But the reality is TMZ, like unfortunately many journalism outlets these days, didn't really do their homework before hitting the send button on this. In reality, the idea that this was the reason for dismissal or that this was some officially final declaration that it's over are both incorrect. So in this video, we are going to dispel some of the myths that are floating around about this dismissal, and we're going to go over what the court's decision really means, both for the class action case and for Coffeezilla's defamation case. Let's get into it. Okay, so if you're new here and you are interested in all things CryptoZoo litigation, we have a full playlist of videos related to the Logan Paul and Coffeezilla defamation case particularly. So if you're not caught up on that one, be sure to check out the playlist linked in the description below. Otherwise, let's dive in. So first, let's talk about procedurally what's going on so that everyone can understand at least where we are. On October 29th, the court in this class action case adopted the report and recommendations by the magistrate judge. Now, in federal court, when someone files a motion, like a motion to is written by a magistrate judge, and it's where you find everything laid out for the reasoning for why the court came to the decision that they did. Basically, it's the magistrate judge recommending to the presiding judge a particular outcome for the motion, and they're saying these are all the reasons why you should end up going this way. Then the judge presiding over the case can decide either to adopt the R&R in whole, in part, or not at all. From what I've seen, for the most part, when a magistrate judge issues a report and recommendation, you can basically expect that the presiding judge is going to probably adopt it completely. And here, a bunch of motions were filed around the same time over the summer. These were motions to dismiss, which were filed by defendants Logan Paul, Jeffrey Levin, Ofer Bentov, and Danielle Strobel. So basically, all of these defendants were saying individually in their motions, I should be dismissed from this case, and these are all the reasons why. Now, Logan Paul also filed a motion for entry of default judgment against two of his other co-defendants, Eddie Ibanez and Jake Greenbaum. This is because Ibanez and Greenbaum have completely failed to show up in the litigation. They haven't responded to the complaint with any kind of an answer, a motion to dismiss, nothing. And when a defendant does that, after a long enough period of time, the court will issue an entry of default. That basically says this guy was supposed to show up and he didn't, and now as a result, he loses by default. Now, after that happens, the plaintiff, or in this case, a co-defendant who has filed cross claims against the defaulting defendant, can request a judgment of default. That basically means the court says that the decision to enter default against them is final. They can no longer come back and try to beg the court for forgiveness and promise to participate in the litigation from this point further. And that would mean that whoever is asking for the default judgment can then start the process of trying to collect from that defendant. So those are all the motions for which the magistrate judge issued reports and recommendations back in July and August of this year. Now, up until now, I haven't talked too much about the class action case, except for where it's come up in relation to the defamation case. Most recently, I talked about these reports and recommendations in my video about the court doing what I thought was perhaps dropping some kind of a hint as to something that might not be so great for Logan Paul in the defamation case. And actually, this is probably a good time for me to correct something that I said that was wrong in that video. Specifically, I said that the other defendants who filed motions to dismiss, Strobel, Levin, and Bentov, that they were recommended to be dismissed with prejudice. But now that I look back at those R&Rs now, it totally says they were dismissed without prejudice. The difference is that dismissing it with prejudice means that it can never come back, but dismissing it without prejudice, as I'll get into a little bit more detail later, means that there is an opportunity to perhaps refile after an amendment. Honestly, I don't know why I got this detail wrong. Maybe it was the stresses of moving that made me hallucinate these details, because I 100% read all of these reports and recommendations at the time, but then again, I don't want to give any excuses. The fact is, I got this wrong and I shouldn't have, and I want to correct it now, as embarrassing as it is. Anyway. In this video, we are focusing on the report and recommendation regarding Logan Paul's motion to dismiss, because that's what TMZ talked about in their article, which is getting rinsed and repeated by other journalism outlets elsewhere, to include Dexerto and others. So before we get into those details about the R&R and the order that was adopting it, let's go through exactly what TMZ said about it. But before we do that, I have to thank this video sponsor. This video is sponsored by Huel. Huel is fast, nutritious, complete fuel for busy people. It's not a protein shake or a meal replacement. It's a complete meal. It's backed by dietitians and based on real science and is balanced with protein, carbs, fats, and fiber, and is packed with 27 essential vitamins and minerals. And the Black Edition also has 40 grams of high-quality protein, so helps keep you going for longer. They offer powdered meal mixes, ready-to-drink meals, daily green drinks, and more. And all of it is geared towards helping keep you fueled throughout your day so you can accomplish all the things you need to do. The daily greens are also only 25 calories and have 42 vitamins, minerals, and superfoods with 4 grams of fiber and only 1 gram of sugar. I tried the blueberry, lemon, and thyme one, and I loved the flavor. It was like fizzy water with all this extra goodness in it. But my favorite aspect of all these products is the fact that you can enjoy all of them while on the go. Because I am also a mom trying to juggle the organizing and management of an entire household of people and animals, along with all the things YouTube. And so with all of that, sometimes it's hard to remember to feed myself when I'm busy worrying about whether or not Baby Bites has eaten enough of all the right things throughout the day. And so on days when I'm in a huge rush and I'm not sure I'm going to have time to feed myself, this is a great way to make sure I'm fueled up and able to meet all those demands. And what's more, viewers of this video can get up to 15% off Huel's newest and existing products by clicking on the link in the description below and using the code LEGAL. So be sure to click on the link in the description below and remember to use the code LEGAL. And thanks again to Huel for sponsoring this video. Okay, back to the video, and let's talk about this TMZ article. So the headline reads, Judge finalizes CryptoZoo class action dismissal. And to start off, that's kind of true, kind of not. We'll talk about that more in a minute. But it starts off by saying, Logan Paul's CryptoZoo legal nightmare is officially over because TMZ has learned a judge has reaffirmed the August dismissal of the class action lawsuit against LP, which accused him of defrauding investors in his failed NFT project. And then it goes on to talk a little bit about the CryptoZoo project, etc., etc. Then they said, according to a magistrate judge, the plaintiffs failed to link Logan directly to their alleged losses. This week, a district judge agreed. Paul's attorney, Jeff Neiman, tells TMZ the district judge reaffirmed that ruling, holding once again that no reasonable juror could find Logan's statements misleading or fraudulent. And then they talk about how Logan Paul apparently found out about the report and recommendation on his wedding day to model Nina Agdal, which honestly is neither here nor there. So that article is really short, but the way that it's drafted, it makes it sound like the judge basically decided that there was no way that a reasonable juror could find what Logan Paul did or said to be misleading to the public. And that's because that's essentially what Paul's lawyer told TMZ. TMZ then failed to do what a real journalism outlet should do, which is to verify whether or not that's true, just by, I don't know, reading the order. Because as it turns out, that's really not true, like at all. And the thing is, a lawyer is supposed to represent his or her client zealously. That is absolutely true. It is in every single bar jurisdiction's rules of professional responsibility that I know of. However, there is also a difference between zealously advocating for your client to the media and straight up lying to the media and in turn to the public. And either TMZ misquoted him or took his statement out of some important context, or this guy just is either incompetent or lying through his teeth. Either way, this is at a minimum an affront to the public, and I personally find it gross, to be honest. So now let's talk about what the report and recommendation and the order adopting it actually says and actually means. To start, let me give you a little bit of background about what a motion to dismiss is and what kind of holding that the judge can and will give for that kind of motion. When the judge is analyzing a motion to dismiss, what they're looking for is whether the complaint has been sufficiently pled. That means things like, does it have all the elements of each claim that they're alleging? Do they have enough specific facts that are alleged? Can the judge understand the story of what happened based on what the plaintiff alleged in that complaint? Is this even the type of harm that the plaintiff can sue someone for? Note that these are all legal questions, not questions of fact. The judge is not interested in proving any of these facts or weighing any of these facts or determining how likely or reasonable any of these facts might be. In fact, when analyzing a motion to dismiss, the court actually assumes that all facts alleged by the plaintiff are true and looks to whether legally these claims can hold up in these circumstances. The reason for that is because it's the job of the jury to weigh these facts and to determine what actually is more or less likely to be true. The jury is actually considered the trier of fact, while the judge is considered the trier of law. So anytime someone says that a dismissal of a complaint on a motion to dismiss automatically means anything about the merits of the case, they're bullshitting you. Full stop. And that's what's upsetting to me about this statement by Paul's lawyer, which keeps getting repeated around the internet. For a motion to dismiss, the judge does not decide what a reasonable juror would find misleading or fraudulent. That would involve weighing facts. And importantly, that's not what the magistrate judge or the presiding judge in this particular case decided here in dismissing these claims against Logan Paul. And that leads me to another important detail about the dismissed claims that TMZ and Paul's lawyer completely missed in this article. It's really important for me to note that of the 27 claims against Paul, all of them were dismissed. However, 26 of them were dismissed without prejudice and only one was dismissed with prejudice. And the one that was dismissed with prejudice was under the Commodity Exchange Act, and arguably one of the lesser claims in this particular lawsuit. So what this effectively means is that this report and recommendation serves potentially different functions for the plaintiffs and for the defendant. For the defendant, of course, this means he got his claims dismissed. And yeah, as of this moment, these claims are not active against Logan Paul, and it's up to the plaintiffs to come back and refile these 26 claims and to make enough changes that they will be able to survive another motion to dismiss that he probably will file after that. But for the plaintiffs, this report and recommendation actually serves as a detailed guide or set of instructions for exactly how the plaintiffs need to cure the complaint if they decide to come back with another amended complaint. And I've talked about this before. When it comes to litigation, if you are the defense and you know that the complaint or the first amended complaint, what have you, is really weak, sometimes it's a good idea to attack it and make it go away. But sometimes by filing a motion to dismiss and getting that dismissal, all you end up doing is strengthening the plaintiff's claims. That's because you give them an opportunity to spot the weaknesses in their claims at a very early stage and to sharpen those claims as a result. So if a complaint gets dismissed, for example, and as a result, the plaintiff files an amended complaint that ends up being actually really tight, that makes it easier for the plaintiff or the plaintiffs to prove the case later on down the line. So sometimes, if you're the defense, it's actually better to let the plaintiff sit on a weak complaint for a long time and to conduct their discovery and then hit them with something like a motion for summary judgment, which is a much stronger booting. Now, I have said this about other cases before and then seen those plaintiffs surprisingly not come back and amend. So I'm not saying that it's always a bad idea for a defendant to file a motion to dismiss. But what I'm saying is, if you think that there's a possibility that they might be able to cure those defects and come back and continue the litigation, sometimes it actually ends up really benefiting the plaintiff in the long run that you filed that motion to dismiss. And something that you should definitely understand by now is that when the court grants a motion to dismiss, it doesn't necessarily mean that the case is over for good. In fact, in my experience, it means that you're probably actually about to litigate a bunch more, just back from square one again. Okay, so let's talk a little bit about why the 27 claims were actually dismissed. Now, I'm not going to go into too much detail about every single claim because remember, the report and recommendation talked about 27 causes of action and it's about 75 pages long. But suffice it to say that a bunch of these claims were dismissed because they were asking to hold Logan Paul personally and individually liable for harms resulting from his activities related to CryptoZoo. And so this is where we talk about the difference between suing someone as an individual and suing someone as an agent of an entity like a corporation. When I was an employment litigator in California, I litigated a lot of employment discrimination and retaliation claims against former employers of my clients. And when we filed these complaints, we'd sue the business that had employed the plaintiff, and often also someone like the supervisor or HR director or whoever it was that did the thing that was allegedly unlawful. Like, say, a manager who was inappropriately giving Victoria's Secret gift cards to employees. You know, fun stuff like that. Sometimes these people would be named as defendants as agents of the business, and then other times they might be named as individuals. There are a number of things that this different kind of designation will do, but the biggest one is that it allows the plaintiff to reach into one defendant's pockets or another. If someone was acting on behalf of their employer when they did something that was unlawful, the plaintiff is probably going to try to hook in that employer because that's probably where they're going to be able to collect either a settlement or a judgment. But in this case, with CryptoZoo, the class probably doesn't care so much about having CryptoZoo Inc. in the litigation, although they do need to be there so that they can get important discovery. But if CryptoZoo Inc. is the only defendant in this litigation, the defendants probably are not going to be able to collect anything because I'm pretty sure it has $0 right now. The deep pockets that they want, of course, are people like Logan Paul, Jeffrey Levin, etc. So this is actually a rare occasion where the plaintiffs arguably want these defendants in as individuals as opposed to hooking them in as agents of CryptoZoo Inc. So let's link that back to why some of these claims were dismissed. A bunch of these were the kind of claims that in order to hold Logan Paul individually liable for them, the plaintiffs need to do something called piercing the corporate veil. The corporate veil is essentially a protection for all people who own or work for a corporation so that they don't have to be personally held liable for any problems that arise from their work. The default is that when an agent of a corporation acts on the corporation's behalf, those acts are seen as the acts of the corporation, not the individual. It's like half the reason that anyone sets up a corporation these days. But in order to pierce that corporate veil, there are a bunch of hoops that the plaintiffs have to go through, and that's kind of a lot. It's a pretty tough standard, to be honest. And in this case, the judge said you need to allege a little more to get there. Anyway, aside from these corporate veil issues, then there were the claims under the Securities and Exchange Act, some claims under state laws related to things like deceptive trade practices, as well as common law tort claims against Logan Paul directly, like fraud, breach of contract, unjust enrichment, negligence, and conspiracy to commit fraud and aiding and abetting. So let's focus on the fraud claims, since that's what the TMZ article talked about. Looking at the R&R, the magistrate judge found a number of issues with the plaintiff's fraud claim. The first big one was their pleading of facts to allege the element of materiality. This means that the allegedly fraudulent statements that Logan Paul made have to be the kind of statements that would affect a reasonable person's conduct. And so courts will distinguish between statements that are material misrepresentations and statements that are mere puffery. Someone who's promoting a product, for example, is legally allowed to puff up the product, so to speak. So like world's best cup of coffee. A reasonable person knows that's puffery because how does someone even measure that in the first place? And that's because puffery is usually either one, an exaggerated, blustering, and boasting statement upon which no reasonable buyer would be justified in relying, or two, a general claim of superiority over comparable products that is so vague it can be understood as nothing more than a mere expression of opinion. But on the other hand, if the person promoting the product starts to claim to the public that the product has important features that it doesn't in reality have, now we're getting into the material misrepresentation zone. And here, there are some statements that the magistrate judge determined were mere puffery. These are the statements, CryptoZoo is so fun, and it's a really fun game that makes you money. Oddly enough, the magistrate judge also said that Logan Paul claiming it was backed by a massive team and funded by, quote, like $1 million, also constitutes puffery. However, there are some statements that the magistrate judge said possibly weren't mere puffery and instead could be actionable misrepresentations. Specifically, the court said that it had to do with what Logan Paul and perhaps others said about the game's completion date. Because as we know, as of today's date, the CryptoZoo game has not been finished, at least not by these particular defendants, and it looks like it will never be finished by them. And the magistrate judge said that an affirmation falsely claiming the game was completed and functional by a certain date could totally be material. The only problem is the way that plaintiffs' attorneys drafted these particular allegations is, according to the magistrate judge, vague and confusing. Specifically, here's how they wrote it in the First Amendment complaint. Ultimately, defendants never released the game, although allegedly it was completed in early 2023, despite defendants' statements from 2021 that it had already been completed and tested. The first of these public statements was made during the public announcement of CryptoZoo on August 18th, 2021 by defendant Paul, the majority owner of CryptoZoo and online celebrity, via his YouTube show Impaulsive, claiming the CryptoZoo game was so fun and a really fun game that makes you money. And so the magistrate judge notes confusion about when Paul said the game was completed and tested. Was it in 2021 or 2023? Who exactly said what and when? And was Paul just boasting about how fun the game is, or did he also say that the game was completed in that Impaulsive podcast? Now, personally, I actually can see how Paul calling it a fun game can be a material misrepresentation if he is talking about his own experience playing the game, and in fact, the game doesn't exist at all. But then there's also a difference between a game being completely non-existent and a game that maybe isn't completed, but is at least completed enough to test some of the gameplay to be able to talk about it and advertise it. So given that this is kind of a huge sticking point for the magistrate judge, what I would do if I were going back to amend this complaint is I would make it very clear that Paul said it was a fun game and that it's a fun game that makes you money on X date, along with everything else that he said about it. Now, I don't know if he said in that Impaulsive podcast that he had actually played it or that somebody else had already tested it by that point, but I would absolutely throw as much detail as I could if I were amending this complaint. And I would take great pains to explain how, in context, Logan Paul calling it a fun game meant to the plaintiffs that he had actually played this game in order to have this opinion, and that meant that he was communicating to the public that the game was completed enough in order for Paul to be able to play it. I mean, that's what the Federal Trade Commission rules say, after all. The FTC tries to make it as easy as possible for influencers to find and understand the rules on branding and product endorsement to include brochures like this one. And here, one of the key points that's highlighted is that you can't talk about your experience with a product that you haven't tried. So even if it's more of an opinion statement to say that a game is so fun or a fun game that makes you money, that's still a statement describing Paul's experience with the product, unless he's talking about, it's just a fun concept for the game. So what the plaintiff's lawyers can do here, at least in my opinion anyway, is to take some extra steps to explain that these statements are in fact material misrepresentations because of how they imply that the game existed enough for Paul to have some personal user experience with it before he made those statements. And I would make it very, very clear in the allegations that in reality, the game was not at that time or at any other time completed enough for Paul to have actually played it in order to be able to make that kind of an endorsement. Now, that all, of course, is dependent on when these various statements were made, because another main issue that the magistrate judge found with the fraud claim is with their allegations related to the element of reliance. So whenever we're talking about a defendant committing fraud, the plaintiff has to show that he or she relied to his detriment on defendant's material misrepresentations. And one thing about the fraud claim that's especially difficult for a class action case is that reliance is typically a fact-specific inquiry that's looked at on a case-by-case basis. And according to the magistrate judge, one of the biggest problems here is that the plaintiffs don't say clearly enough when these misrepresentations were made, when the plaintiffs heard them, and when the plaintiffs relied on those statements by investing into CryptoZoo. So like with materiality, the issue of reliance sounds like it could potentially be cured just with some better writing to tell the story of what exactly happened. Now, I didn't follow the CryptoZoo saga until Coffeezilla's 3-part series, so I don't know exactly when Logan Paul or anyone else from the CryptoZoo team made any of these statements to the public. So I don't know how easy or difficult it will be for the plaintiffs to amend this complaint on this issue. But I do think that if they're able to clean up the timeline of their allegations a bit, this claim should perform much better for them. Okay, so now there's a question that I know a lot of people have about all of this, which is what does this all mean for Coffeezilla's case? And I've seen some people out there blackpilling about how this is bad news for Coffeezilla because this fraud claim got struck down and because the statements Coffeezilla made had to do with calling Logan Paul a fraudster or a scammer. Now, I'm here to tell you that I completely disagree with that. Number one, like I said before, this is an order on a motion to dismiss. The order and the report and recommendation before it are not saying anything about the merits of the claim or the evidence in the case. It's saying that the way that the complaint is written has some defects that have to be cured if this case is going to continue. Second, we come back to the fact that in the defamation case, truth of a statement is a complete defense to defamation. So if Coffeezilla called Logan Paul a fraudster or a scammer, and there is some kind of full and final judgment saying that Logan Paul did in fact commit fraud, that's a decision that can be used by Coffeezilla for his complete defense. However, if there's a full and final judgment on the merits coming out of the class action case saying Logan Paul did not commit fraud against the CryptoZoo investors, that still doesn't kill Coffeezilla's defense. And a big reason for that has to do with the fact that a big difference between these two cases is in the burdens of proof. In the class action case, the investors have the burden of proving their claims. But in the defamation case, Logan Paul is the one with the burden of proving every element of defamation. That means he has to prove that the statement Coffeezilla made was false. Yes. In other words, Paul has to affirmatively prove to the jury that he did not commit fraud against the CryptoZoo defendants. He also has to prove all the other elements to include actual malice, which, by the way, is typically very hard to prove. Because Even if Coffeezilla made a false statement of fact about Paul, it's still not defamation if he reasonably believed that what he was saying was true. And I've talked a bunch of times about why I think Logan Paul is likely to have a very hard time proving actual malice, unless of course there's some smoking gun evidence that I don't know about. That is always possible. But aside from that, from what we know, I simply don't see Paul winning the defamation case. But going back to the fact that Paul has to prove that the statement that Coffeezilla made was false, here are a couple more reasons why I think this dismissal doesn't impact Coffeezilla's defense. For one thing, the two sides will have to fight over what it means to call Logan Paul a fraudster or a scammer using the language that Coffeezilla used. More to the point, what's going to matter here is what a reasonable recipient of these statements would interpret a fraud or a scam or a scammer to be. And that may or may not be a strictly legal definition. It could mean that a reasonable listener thinks that a scammer just means someone misrepresented the truth about something important to the public for the purposes of trying to make a profit, and that members of the public got harmed as a result. What I'm trying to get at is the level of difficulty that the CryptoZoo investors have to rise to in order to win on their fraud claim is likely much higher than what needs to be shown in the defamation case for what fraud or scammer means. To that point, it's important to note that the magistrate judge in the report and recommendation also highlighted the fact that the fraud claim here has a heightened pleading standard. This means that in comparison to other claims, the plaintiff has to plead a little more in order to sufficiently state the claim. So if the bar for the class action plaintiffs is up here, Coffeezilla may or may not even need to reach up to that level. His bar may be down here where it's a bit easier to prove that his statements calling Logan Paul a scammer were actually truthful. And one final note about the truth or falsity of the statement. There also exists a distinct possibility that the class action plaintiffs are, in their case, unable to prove that Logan Paul committed fraud against them, and where Logan Paul is also unable to prove that he didn't commit fraud against them. Remember, I said earlier that the difference between these two cases, at least as to Logan Paul himself, is that in the class action case, he doesn't have the burden, but in the defamation case, he has all of the burden. So the class action plaintiffs might not have enough evidence to convince their jury that Logan Paul, more likely than not, committed fraud. And then in the defamation case, Logan Paul also might not have enough evidence to convince a separate jury of the inverse. So all of this is to say that I personally think that this dismissal has little to no bearing on Coffeezilla's defamation case. And depending on what the plaintiffs and the plaintiffs' lawyers decide to do, this might not even be the end of the class action case as to Logan Paul either. And while we all make mistakes, I had to correct something earlier in this video that I had said wrong in a previous video after all. There's just something about the sheer laziness of the media on this one that really upset me. But those are my thoughts. What do you think? Going into this video, did you read any of these headlines or any of these social media posts from these journalism outlets? And did you think that the judge had decided that no reasonable juror would find that Logan Paul made any misleading or fraudulent statements? What do you think about the outlook of the class action case and the defamation case? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.